think we have a very interesting as well as important topic. Of the things I've learned about business, one is that you must keep your customers close, but your lawyers closer. So I'm really looking forward to the discussion. We usually have a Q&A session after the whole thing, but since this time we're gonna cover three kind of separate topics. So I'll be asking you to ask your questions if you have any, just when we'll be moving across the topics. We have received a couple of questions beforehand. Not all of them were on point, so we're very sorry, but we won't be able to answer them. And when you'll be raising your questions here live during this event, please be on point as well, because we won't be answering any other questions regarding intellectual property or anything else, all right? It's my pleasure and honor to introduce Akvilė. Hi. Yeah. Jovita. And Elena. Yeah? All right, so let's start from very beginning. We gather a couple of guys gathered together. They have an idea that's going to conquer the world. And before, do they have to agree on how they roll before they start? Do they make the agreement when the product is going? How do founders, co-founders form the agreements? When is the best time to do that? What's your take about it?
Well, basically, from our experience, it's usually, just when the gang gathers and, just some idea pops out, it's usually, not the time, basically, to structure just the relationship and discuss, how we'll be moving forward in 10 or 12 years, because, the idea might collapse like in 1 month. So, but of course, it's very important that basically all the co-founders have the same, idea how to approach the business, how they divide or will divide the percentage of the shares in the future, or just the current company if they establish one at the beginning, and what they aim basically. Do they aim for the investment from the just some seed funds, or do they want some crowdfunding, etc.? Because it's also like these strategies that has impact on future just actions of the co-founders. So, and I've seen just a number of situations, when just a group of guys come and say, just yes, we have agreed like everything, it's clear, just we want, just to check several points. And when we start asking, what they have agreed, it just appears that just they have some general understanding what they agreed, but just when we dig deeper, it differs. So and what I want to say, just you do not need to have, just a shareholders agreement, just with 20 pages long from the beginning, etc. But it's good that just and should be that you know how you divide your shares, how you divide your roles, how do you divide just your roles in the management or in the development of the company, and where are you pointing at. And usually just it's fine for the just co-founders to have this as an understanding on gentleman's understanding, or some, I don't know, one-page agreement, just because further on, if the business develops, of course, and some investors come, then it will be the stage basically to draft all the legal documentation and other stuff. Yeah, just it should, just the guys should know where they aim and how they divide, this future Google
where
company.
They aim, you mean the strategy regarding investment? Or
because basically, just if the guy is just if there is some idea and just okay, somebody, they have some cash for the start, but it usually runs out very, very quickly. And, you know, just then basically the co-founders start, you know, to think where to get the cash out, you know. So it's good that, for example, if you have an idea, you know, start testing it with the, some funds, you know, just whether they would be interested in investing it if, you know, the idea is developed to a certain extent, or, for example, you know, just to search for some crowdfunding platforms or some other, you know, initiatives, how to raise the money, because it's not the time just to think of, you know, raising future money when they just run out and you have no basically cash in your accounts or in your pocket.
So you suggest starting with a maximum one-pager agreement, yeah? Just dividing the more or less percentage, and that's all, without even thinking of what happens if one guy is fed up with the others and decides to leave, but the company is kind of growing, you know. Do we have any protection in this case?
Yeah, basically, of course, you know, just from the ideal legal point of view, it would be nice to have, you know, shareholders agreement with all the situations, you know, and all the, as we say, legal, you know, just language drag along, tag along, deadlock situations basically solved. But you know, if we're talking about, you know, the group of guys or ladies just, you know, gathering and just starting the business, so it's usually not the point basically just to enter into agreements and, you know, sit for like 1 month and negotiate the terms, because it's the point to do the business. Of course, if then, you know, the idea grows and you see that the company develops, you might discuss, you know, and just, you know, and if somebody leaves the company, you know, just what you will do. But just from my practice, you know, usually just, well, when the other just money comes from the investors or some just, you know, some fund, then basically it's the time to agree the terms and to discuss, you know, what happened if somebody leaves, or just if somebody is sick, or just, you know, lost the interest, etc. But well, as I said, from the ideal point of view, of course, it would be nice, you know, just to agree on everything. But I wouldn't just suggest to waste your time or money, just to agree those things from the start.
Yes, we have one of the questions was we have this description of a situation where a couple of guys got together and they spent around 25,000 on legal expenses, drafting their legal matters, and then they didn't have operating cash to do the business. So that really seconds to what you have already said. I have seen this in my own experience as well. When you start digging into legal matters too early and start talking about how you're gonna divide in case of a division, two things happen. You waste your time not doing business at this point of time, and then there's this psychological aspect of it when you, instead of being driven by the vision to conquer the world, you are digging into the negative scenario, right? So I think this idea of a one-pager, I could have known it before, you know, because we were drafting also, not for 25K, but we were drafting pretty serious stuff, and it really has this. When the business is so young, you don't want to spend the time in the negative scenario, but you wanna. You want to work.
And also it's important that, you know, just when the idea is quite fresh, basically, for example, if you have like 3 guys, you know, just having one idea, working on the development of it, and for example, you know, in some early stage, for example, you just discuss incorporate the company, and in some early stage, one of them leaves, for example, you know, for Great Britain to work in some other sphere, and just you remain 2 of you, and just you are thinking, why should we just work for this company when we have have the other shareholder who is not active in the process. But just usually in those early stages, the idea hasn't materialized. It has no IP protection. It's basically, it's nothing, it's knowledge, it's in the minds of the founders. So, in such a situation, then basically it's better for those two guys to set up a new company and just, develop the idea on the new company, because it's no, basically tangible or intangible assets to transfer from one company to another. Because, of course, when the business and the idea develops and, you have all your IP set, just trademarks, I don't know, some know-how already, in place, then it's just this transfer of ideas, from one company to another is basically, well, quite cumbersome, and it may cause legal and tax issues. But from the start, if you just do not agree with one of your partners, it's basically best, to divide and to start everything from anew, because it does takes only like 2.5k euros to start new company.
The cheaper way.
Cheaper way, not 25. Yes.
Okay, so it seems that before any capital raise event, you don't sign the agreement with the co-founders. That brings us to the agreements with the investors. So what are the main points in contracts, generally speaking, contract with the investor? What are the main points? And since the crowd here is the the entrepreneurial gang, so how do you protect your interests while talking to the investors, while drafting the agreement?
Yeah, basically it very much depends on the type of the investor, if whether it's an active investor or inactive one, because certain investors, usually the business angels, they take quite active role in the development of the idea of the business of the company, and just they want to have either some managerial role or some just some other just position in the management, or be active in advising the company. So in such a situation, just the agreement with such an active investor, just you usually agree, just what scope of his functions will be, of course, what he will get for his investment in the company, whether it's shares straight ahead, or whether it's some option, which is also the case, or some convertible bonds, etc. So just you basically agree what you will give for your investor or business angel for just working with you for the development of the idea. And then, of course, it depends very much on the investor himself or herself, and on just how much they experienced and want to get into very legal stuff, because again, I have seen a number of those active or business angel investors were fine to get some roles, some shares, and basically then everything is according to the law, with no specific agreements. Some investors, as in the case you've described with 25k, I understand just they want to have like full protection, some control rights, some voting rights, just they agree on the quorum, just for maybe some veto rights, then basically on various mechanisms how the shares will be transferred after just the investor becomes the shareholder. That, for example, nobody will transfer without the consent of the investor, or that, for example, if the investor transfers his shares to somebody else, then he has the right to drag the co-founders with him. So the various mechanisms. So it's, one part of those active investors. Then there is inactive investors, as we call them, who are mainly concentrating, just on veto rights. So basically they are not, they are like, like funds, for example, various seed and venture funds. They are providing basically investment, they are providing cash, but they say that as long as you are doing fine, we will not do anything. Just we are only providing cash. And we will only control you through some veto rights, just passing the decisions, some information rights that you will provide us financial statements, some, other management accounts that we see, that just where you are spending your cash and where your business is going. And, some also like share transfer mechanisms. But basically it's very much depend then on the fund strategy, you know, because there are funds operating also in the Baltics and of course in the worldwide that, you know, just the agreements are quite simple, like 1-2 pages. There are funds that they have agreements of 30 or 40 pages, you know, just also trying to catch all the situations, you know. So it depends, you know, how the fund is, you know, and fund managers are relaxed, or, you know, just they are aiming at just at profit and development of the companies. So there is no, like, you know, unique answer, you know, what you have to agree and how to protect your interests. But of course, every entrepreneur, every startup should think of, you know, how he will operate the day-to-day business of the company with the investor already on board, whether he will need to have consent for each and every decision, or for example, he will need to approve only, you know, some business plan, some budget, and then operate quite freely, because it also has, you know, just on day-to-day operations, it has quite big impact, you know, whether you need to search, you know, and just for your investor to have a sign-off for every, like, purchase or some idea, or that whether, you know, you just say that, okay, I will do, you know, just my strategy for half a year is this, I will have such spending, such income, or without income usually, and then just you operate quite freely, and then just only consult on the major just decisions if they pop out. So, but just, you know, usually it's the one who brings the cash, he dictates the conditions, because
absolutely, yeah. The bargaining power of a startup here is not that big, I guess.
Well, I think it, you know, it's
in terms of the structure of legal contracts and stuff.
Yes, it's, you know, it's maybe not so big, but of course it depends, you know, whether the idea is attractive and how many, you know, funds wants to, or investors want to invest into the idea. Because I've seen cases, you know, when, for example, some entrepreneurs come to the, you know, just some startup funds and say, I have this idea, but, you know, if you just put very strict terms on me, I have like 2 other funds waiting just behind the door. And then, you know, just the strategy of the fund just it changes, because there's, you know, then they are quite open to discuss and they're not dictating the terms. So, but of course, if you just found only one person or one just fund who are investing into your ideas, you are not in the position like to dictate what you want.
Maybe then there's a workaround of information management, so to call, and you might might hint your potential investor that, look, there's a line, not necessarily there is one, but you can say so, can't you?
Yes, basically, of course, you can, you
just
know,
for the management of bargaining power. Huh?
Yes, you can do that, but you know, just usually, again, just our market is quite small, basically, and everybody knows each other, you know, and like, you know, just if some good idea pops out, and, you know, just the word is spread around, and just, you know, then you see, you know, that, you know, there is an interest or general interest in the idea, or then there is no, basically, and you are the one investor, only one investing. So, but in any case, of course, it's very important for the co-founders, just, you know, for example, when the investor provides some terms on which he will invest, to analyze those terms with the lawyer, I would say, you know, just who will explain, you know, what all these provisions, you know, and those words that I was mentioning, deadlock, drag along, tag along, what they mean, because there's usually the term sheet, you know, just that the investor provides to the co-founders, to the entrepreneurs, is like, you know, 2 pages, and, you know, stating drag along, anti-dilution, as usual, basically. And what is usually usual, and what does it mean in practice, just, you know, it could be explained by the lawyers who really done, you know, deals with that and seen how it works. So it's good, you know, that just to consult the lawyer, just, and, you know, then to discuss how the interest could be protected, because, you know, as I said, the vital things are, you know, how the business will be run, the day-to-day operations, how the shares, you know, will be transferred, whether you will be aiming at the exit or some, you know, Series A, Series B, etc., just rounds, and who will be responsible for that, and, you know, whether, you know, just somebody can drag you, you know, just and to force you to sell the shares or not, and what happens if you leave the company, or if you are bored with the company and found better job than being an entrepreneur. So, but it very much depends on the funds that are investing and the conditions initial conditions that they provide.
I know that some startups are even forced to change the jurisdiction. That happens more with the international investors, obviously. So, from your practice, what's the percentage in our market? What's the movement here?
Yeah, basically, the percentage is quite low because we are only talking, we are calling that flip to, to UK or after Brexit, I don't know, to US or Berlin, whatever. Because basically, usually if the idea emerges in the Lithuania or in the Baltic regions, then it is the local investors and local funds who are investing into that idea, and nobody requires, that you just be incorporated in the UK at once, basically. And it's usually the companies start here, they grow here, and they receive the first investments, usually, just maybe also Series A investments here, and then if the big funds already come, just to invest, like Intel, Google, just Octopus, whatever, then they just ask the company headquarters to be moved to UK usually, or US, where they are more familiar with the legal environment, and just to make this flip. Because, for the big funds, of course, they are not ready to invest into the consultation with lawyers, with local lawyers, and just digging in what is the legal regime in Lithuania, Estonia, or Latvia. And they say, just if you want our money, which are usually quite big, just please go to UK, because we know how the structures and legal system work there, and we will give you money there. But it's, it's only for those companies who are very successful, who already attract attention of the big venture funds, and then just basically they move to the other jurisdictions. And we have already in Lithuania we have Trafi, we have TransferGo, who basically did the flips, and several others. So.
All right. So just before turning to the audience for questions, I have a question. We had a couple of months ago, we had a CTO of TransferGo here. And he talked about his experience in a previous, there was some food delivery last mile startup in the UK, and he told this the story that they were looking for capital, and they were pitching to some investors who took their know-how and went to their competitor and backed their competitor by investment, and also by their know-how. Legally, how to protect your idea, your know-how in such cases when you go to talk to the investor. Also, maybe you can touch. So, how open should you be talking with the investor in this? In the sense as to tell enough for them to invest, but to keep enough so that they, in case of such I don't know, not very nice business practices. So how do you protect yourself in such case?
Yeah, quite a tricky question, because just on one hand you want just to receive money, and on the other hand you're afraid that basically your potential investor will just be some crack and just basically will take your ideas away. So of course, if we are talking about the business, already just to some stage developed business whose ideas are protected by just normal IP rights, some trademarks, etc., then it's it's not such a big threat. But usually it's know-how that that matters on which those businesses are driven. So just I would say that there is always a risk, because you cannot just go to the investor and say, yes, I have some idea, describe it in one sentence, and expect that the investor will invest into you. And there is always some level, you know, of just of trust that you have to put, and you know, just of course, just to do that, you just need to do some, you know, screening of, you know, who you are talking with, and just to ask, you know, your colleagues whether they heard any bad rumors about that guy or that company. But what I've seen in my practice, that, you know, usually if it's some, you know, high tech or some technology companies, you know, just those processes that they rely on, they are very complicated, you know, and for the fund, you basically to decide whether to invest or not, it's not necessary to dig into that process, you know, just and to understand, you know, what codes you are using, etc., etc. It's basically just the fund, when it makes decision to invest, they are just looking at the product or the idea, just its main, okay, how it works, its main principles, but not, you know, digging like, please describe me your know-how on the paper, and then I will review whether it works. So if you just hear this request, just please describe everything, and then I will examine, then just you might get cautious that maybe there is something wrong. But just otherwise, yeah, just those funds, you know, who are investing, they just testing the general idea, whether just they like the concept or not. And, you know, since they are just the investors, the investments range, you know, from, I don't know, some IT, you know, issues, then, you know, some phishing issues, then, you know, some medical stuff. So, you know, just it's impossible for one guy basically to know everything, and that's why those investors, they are more concentrating on high level. But yes, I've also seen stories, you know, when, for example, especially in the early stage, when it's only the idea, you know, and nobody, just it's a very good and, you know, interesting idea which nobody thought of before, then there are just, sometimes there are stories when, you know, just potential investors, they just basically took the idea away and basically did something, you know, on the side. But
so if you had this one brilliant idea that no one had thought about, and you were going to pitch to investors, how would you try to protect yourself?
I would develop this idea, you know, maybe to some stage, you know, when it's not only, you know, just one sentence, it's some deeper that, you know, I am the one who knows, you know, how to do that, or you know, how basically to develop the idea. And of course, I would make a screening of the guys that I'm talking with, because it's especially in such a market as Lithuania, it's so easy. In London, yes, just it's more, you know, just complicated, but even in London, you know, just you can just say, you know, just and search for contacts who knows that person, and that get references. So and basically when talking just to the potential investor, just, you know, you need to have a feeling, you know, whether just the investor is digging, you know, and asking, you know, the things with an interest to invest, or just, you know, is interested about the idea, not talking about cash, and then just basically when wants to go back to his office to do the same.
All right, thank you. So, do we have any questions on co-founder agreements and or investor agreements? Please, and be loud. Yeah.
I have a question related to the topic to the co-founders. What main clauses should be included in the one-page agreement with the co-founder?
Basically, the split of the shares. If you are already incorporating the company, you know how many shares just each of you will have. The role, just what each of you will do, and just, you know, how you will approach the further, you know, raise of cash. If you already know that, or just, you know, to lead that to discussions, or at least to consider several ideas. I would say these things.
Decision making?
You know, just it will very much depend on the split of the shares, because if you just are very, like, you know, just from the start, for example, if you have 3 guys, one, for example, I don't know,
developer, business guy, and
but for example, you know, just each having 1/3 of the shares, then just naturally, the business will be done by just day-to-day business by the CEO. So it's very important that you agree, you know, on the roles who are the CEO and who are just development manager. And those basic decisions, main decisions, will be taken by the shareholders meeting, where you will just, you know, just you have the rules in the law that you do not need to amend from, so from the start, because if you will say that, everybody has like a veto right, then I'm afraid that you will not pass any decision. So it's, I would say, it's quite okay to have them.
Okay, thank you. Yeah, there was another question here.
On the last point, covered before the questions with regards to saving yourself from investors who actually kind of try to steal your IP. You mentioned soft measures of screening each other, but is there a practice in Lithuania to actually control this process with hard measures like NDAs, and which are enforceable, and sort of non-bollocks NDAs, anyway? Because this is quite a sensitive thing, and I've heard in other jurisdictions that you start off your discussion if you want to dive deeper with an NDA.
Yes, in NDA or just confidentiality agreements, they are just very good legal stuff. But since we were talking about practice and reality, let's say just you have the investor, just you give him an NDA just to sign, he signs it, and then you discuss, just you disclose, what your idea is, and then the investor, just goes and, for example, another company makes, just your idea live. How you will prove that you will just disclose the idea? Just how you'll prove that this investor used it and didn't, think of his, mind. Just it's so many, enforcement issues that basically you might have a lot of, legal documentation, because everything what comes to confidentiality, just you may have fines, you may have, arbitration, etc. But in order to bring the legal procedures, you will need to have quite a lot of cash to pay to lawyers, to pay to court, arbitration, etc. And you will be so stuck with, proving just your truth, that in the end of the day you will think that it's better to think of another idea and to develop that than to chase this bad investor. So
this purely legal way is not basically viable?
Well, basically, it's nice to have those NDAs, but, having it...
Everybody does it,
yeah,
so why not?
Yeah, everybody does it, and it's nice to have it, but, you wanted to hear my practical points.
Absolutely.
So I'm saying that, yes, as a lawyer, of course, NDA, wow, really is a very good tool, but from practical side, just it's very, very hard to enforce, and I wouldn't say that, it's the tool to protect.
So there's no precedence where, let's say, this startup party would have defended its rights?
I haven't, searched for this specific statistics, but no, I haven't heard of cases, at least in Lithuania. But, just if take the Lithuania or the Baltics, I had heard of 1 or 2 cases where, with this bad experience, because, as I said, it's a small market, and if it's done one time, just the word is spread very, very quickly. So, it's not basically the normal thing.
It's not a common practice, and people think about their reputation.
Yes, yes.
And by the way, this case I was referring to, it was from the UK market, so where we know the forest is bigger and more places to hide, I guess. Okay, any more questions, please?
Would you say it would be possible to protect yourself from a partner who is not delivering on his role in, let's say, in some, after a few months or maybe in 6 months or so from the start, you notice that a partner is not delivering anymore, and would you say it's possible to actually protect yourself from that?
Just one pager.
Yeah, but that one pager or 2 pagers.
Yeah, but just again, just if we are talking, from this early stage, you can have, not one pager, but, just more broader agreement, saying that you will have, for example, shootout mechanism, meaning that you can force your co-founder to sell the shares to you, or at least to buy your shares back from you, if, something happens. But again, looking how you will enforce that, and how you will prove that he's not delivering, because maybe he thinks that he's delivering. Yeah. So, just again, I know that we are representing law firm, and I should talk, from legal terms, but I want to talk, from practical side as well. So I would say that it's this early stage, then basically it's better to just split and go and you establish your own company, and you just develop the idea on your own. Because if you get again into just negotiations and conflict with your co-founder at this early stage, when basically there is nothing already, some developed, some intangible or intangible things.
But look,
Yes.
if we have a situation that okay, so we are, let's say, 3 guys, we came with this brilliant new platform for whatever it is, yeah. The work for development of the platform is like okay, 6 months, and we're 4 months into development. So there's quite a few lines of code written already, which is a tangible asset. And then we see that one lazy bastard is not performing. We have tangible asset, code nearly written, not all bugs is fixed, but still. So we have a tangible asset that's the property of the company. We all share, like, okay, in equal parts. How do we kick him out?
Basically, if you do not have an agreement from the start that just you can kick him out if he underperforms, then just it's no possibility in Lithuania to kick out somebody of the company from the shareholder's position. Just if you have no contractual just arrangements beforehand.
Then can we found new company and then just we bring the code to there?
You can do that, but if the guy who is underperforming, he is clever enough and he is angry enough, he may challenge this, transfer. So basically, just there are like 2 options. First, you just sit and agree. It's everybody thinks that law is something that will solve the issues. No, basically people need to talk and to agree that, for example, you will buy the shares for a certain price. Okay, maybe the payment will be deferred to raising the new money, etc. Just there are ways to structure it, but basically you sit and decide, just agree, what to do, how to approach, because one is guys are not performing. Of course, you might try, just to agree on those issues beforehand, before just when you just gather and think of the idea and just try to put that into paper. But then you will run not into one pager, you will run into just 2 or 3 months discussion, how you describe this underperforming. Then because, in order to describe what is underperforming, you need to describe what are the milestones, etc. And it's already these technicalities that basically you may sit, and just in several rounds or in a number of rounds and agree that, that this guy will be responsible for these milestones, this guy for this, and if one of the milestones is not achieved, then the others will be just entitled to buy the shares for a price that you will also need to agree beforehand, just signing the agreement. So it's just I've seen models, when the co-founders did that, from the start, but it really took not 1 month, it really took several months. And just, then it's more complicated documentation. And if you have cash, just and time to do that, then of course it's a nice thing to have. But usually, there is no cash, there is no time, because everyone to make business. And well, it's basically then you sit and agree.
I have one question. From your practice, yes? You've seen a lot of shareholders, startups. What is the most successful number of shareholders that are starting the journey?
Usually for just because it's different for startups and for other companies. Just for startups, usually just we are seeing the teams of 3-4 persons. But I must say that, just in 1 or 2 years, in most of the cases, it's either 1 or 2 remaining. Basically, they sit, agree, because one is underperforming, just, they buy the shares, etc. So, of course, there are just, the teams that, for example, started as 4 and they are continuing as 4. But just if to take statistics, just the number is usually 3-4, but it ends with 1 or 2. So I would say two is Yeah, 2 is more optimal. And of course, when we're talking about 2, I'm always saying to my clients not to make the mistake to divide the shares 50-50, because it's the worst situation that can ever happen. Just somebody has to take 50 plus 1 share and the other 50 minus 1, because somebody needs to have a decisive role, just you know, and just to make those
Not to
crucial
stale
decisions.
the decision.
Yeah.
It makes sense that 51% that has shares is also the manager, and if he's not the manager, he has less shares, and he does not have them.
Yeah, just, you know, of course, the manager, you know, can be also the guy with 49%, but the guy with 51% will be entitled to replace that guy anytime. So, but you need just, you know, starting the business, it's good to agree that, you know, somebody will be, you know, the leader to take this, you know, 51 shares. Because otherwise, you know, just you will be stuck with, you know, with deadlock situation, what to do, you know, 50-50, nobody can take decision, you know, nobody, for example, the manager is not performing, but it's impossible to replace him because it's 50-50. So it's, you know, things like that.
Okay, and the last question here.
I wanted to return to this, let me see. So basically, from legal point of view, there are like no sufficient legal mechanisms to protect this idea, right? Like a really good.
No, just there are like, you know, just it's already just another sphere. It's intellectual property law, you know, that basically it depends on what your idea is and how it can be protected. Because just there are like, you know, copyrights, just trademarks, as I said, you know, some patents, etc. But it very much depends on the idea. But in most cases, what I've seen in my practice, you know, the idea is basically, you know, just some know-how. And, you know, if it's in your head, or even if it's written, you know, just basically to protect it, you know, it's like, it's so intangible. It has, you know, it can be duplicated quite easily, you know, and it's quite hard to protect.
What my own answer for myself in this in such a situation is like having really deep knowledge about it, demonstrating your competence to the investor, because he buys your competence, and not giving the really sensitive information. That's the only way to protect. The sensitive information is keeping for ourselves. I think it's
yeah, for example,
the
you know,
enforceability is really what can you do about it, and how much it's going to cost you.
Yes, and you know, just the example with the code, you know, you just describe the idea, you know, but you're not giving the codes, you know, just and because, well, it's not necessary to make an investment decision. So it quite depends on the situation.
Okay, so while we were discussing here, our company has matured, and we're now looking into employee stock options as probably as means to motivate the employees. What are the motivations for stock options for employees? Motivation, retention?
Yeah, I guess from the statistics we've seen, retention is the core motivation for the companies to offer stock options for the employees. Then, like I'm working with taxes, of course, it was very interesting for me to look for statistics in which in what is tax savings in the line of all the motivations. So it's like the least. So this having many, if I can say, not compliments to Lithuanian tax system, it's probably good. The tax is not the core motivation for companies to offer stock options. So basically, retention.
Yeah. So yes, Elena and I found some quite interesting statistics, and actually we have found out that companies, around 33% of companies don't even think about taxes when taking the decision to structure stock options in the company. And we will talk a little bit later why this could be a good thing and why this could be a bad thing. Because around 5 or 6% think how to basically not pay taxes or pay less taxes for the company. Around a similar amount think how to pay less taxes for the employee, and the rest think how to save taxes for both parties. Around 33% don't think about taxes at all, and they think employee retention, maybe employee enrichment, and other sort of factors. And why stock options could be an interesting tool and a good tool to motivate the employees, because basically the employees ultimately feel like shareholders of the company, because you promise this idea that you make an agreement with the employee, and in some point in the future the employee will get the ability to purchase the shares of the company or the mother company and so on, or the sister company and so on and so forth. So basically the employee will gain the ability to purchase the shares, become the shareholder, and as the price of the shares grows and as the company becomes more successful, he will in turn get richer. So you will basically think that you will have the .com boom, or the Google, the Uber and all of that, the Airbnb kind of situation. But also I think we should mention a few drawbacks or kind of difficult areas why the stock option might not be the best tool to motivate your employees, because I specialize in employment law and I think about this tool from a very practical point of view, because it's a complex tool, and to set it up in motion it could take a lot of legal work and a lot of decisions, because you have to make multiple decisions when you actually get this tool working. So at first you have to decide how many percentage of the shares of the company will you give to the employees. So is it 5%, is it 10%, is it 15%, what will be the amount of the shares? Then you have to think who will be the employees that you will give these shares to, or make this stock option agreement. Because maybe you could choose all the employees and you will say, okay, everybody gets a piece of this pie. Or maybe you will say just the top management, or just, the somebody who is really special in the company. And, maybe those guys who write the code, because basically they create the product in the company. So you have to make, this decision. And then you have to think about psychological factor as well, because if you give this, this tool or this possibility to be rich just for part of the employees of the company, will the other employees don't feel good about the situation or not? Because they might feel that they are not valued enough in the company, because they don't get, this kind of possibility to get the shares of the company. So you have to think about that. And then you have to decide the period. So you have decided how many shares of the company you will give, to whom you will give the shares. Then you have to decide when you will give the shares and what kind of shares. Will you give the so-called old shares, so that the shares that the current shareholders already have, or will you issue a new emission of shares and then divide that new emission to the employees? So you have to think about that. And
so it's really like whoa.
I mean, there are a lot of decisions.
Let's roll back a little.
So if you thought that Akvilė was talking about, she was talking about serious things, but if you thought that she was talking about many points to consider, I mean, stock options, much more points to consider.
Okay, so let's start, little by little.
Okay.
Leaving the older or traditional companies aside, let's talk about the startup world. And from your experience, when do companies start considering stock options for employees? When do you think is what what signs might say that it's about time to start thinking? Like what's the level of maturity maybe across the verticals? I don't know what's the differentiation, but so when do we start thinking about it?
Well, first of all, you have to program one thing into basically your company. If you are even considering stock options, it's the exit. You have to think ultimately about the exit, because stock options don't work if there is no exit. If the company doesn't IPO,
or any liquidity event.
Yes, or if the company does not sell, doesn't get acquired, basically it will be very hard to sell the shares at a good price. So basically, privately held companies, their stock options, I wouldn't say that it's the best tool. So if you want to really get the maximum amount of employee retention and all those benefits and all those factors, you have to think whether or not you will actually make an exit. Because if you will, then yes, I believe it could be a good tool. An employee will actually gain something from that. If you will not make an exit, or if you're not even planning to make an exit at some point in the near future, then at first it will be very hard to explain the employee what will be the gain for him, and then it will be very hard to convince him that he will be able to sell the shares of this company. Because, I mean, can you guarantee that the company will be successful if you are putting certain efforts for the company to make an exit? Then yes, I guess you can bet a little bit more on that.
Yes, and I maybe can add that usually this exit panorama is seen when the serious when the investors come with their just cashes, for example some startup funds or some venture funds, and basically it's usually the moment when those employee stock option plans are set, because it's of course driven by the funds, by the investors, that just there should be some just a pool for the employees just to participate in the option. And just in this, just during this moment, when just this new investment comes, then the company is already like tested that it's okay, it's not super successful, but it's already successful because because somebody already just is investing and it caught attention, just all the investors. So it's just from our practice, it's usually the moment when those stock options they appear, not beforehand, because it's usually we are talking beforehand is co-founders who are usually all the shareholders, and when the bigger money come, then it's usually just to discuss those options just to motivate other employees, not co-founders.
So basically you're cool with what investor offers, what's his practice regarding stock options. So what's regarding diluting shares by by issuing new stocks or selling some of the old stocks. What's the practice here in Lithuania? What have you seen? How do companies structure these deals?
Well, in practice, at least in Lithuania, it's very difficult to issue new shares. So in my practice, I've seen a few cases when the old shares were sold. However, we will, I don't know whether that's the right time to start talking about taxes and 100 steps to think about taxation, but like very generally. Very generally, like we have from 2016, Lithuania offers the tax incentive on social security taxation, where like which the definition of the taxation and is very narrow and very wide at the same time, because it's one sentence in the law on social security which says that. If an employer receives shares after 3 years of vesting period, then this income is not regarded as employment-related income, therefore is exempt from social security taxation. However, the law does not specify what kind of shares it should be, whether these shares should be newly issued or the shares should be acquired from current shareholders. What kind of shares these are the shares in the company the employee is working, or the mother's parents, grandparents' company. So we will come to that, but basically in my practice I've seen the sale of shares mainly. Perhaps
All
the
shares,
colleagues.
Yeah, and just one problem with the new shares is that if you take the worldwide practice, of course everybody is talking about new shares. Nobody is talking about old shares because it's some just it's not understandable in normal world. But just if we are talking about Lithuanian specifics, then we have a saying in the laws that if you have just issuing new shares, then the new shares have to be paid out, and just by paying the nominal price, or the par value, you may call it. So, for example, if you have if you are issuing, I don't know, 100 shares, which has 100 par value each, then you need just for the employee to pay 1,000 from his pocket to get those shares, and usually it's quite small amount. Okay, but if we're talking about already more developed companies, bigger amounts, and it's always a question how nobody wants to take cash out of the pocket to receive some shares. So it's usually just structured as sale of the old shares at some fractional price, €1, etc. Because it's easier just to motivate the employees, saying just you can take the shares for €1, not considering tax issues, but not just pay 1,000, 10,000, etc. just to receive the shares that you will probably sell or not sell just during the liquidity event.
Mm-hmm. And have you seen cases where you don't issue stock or you don't transfer the stock for the employee, but you just make a deal to share that he will receive a profit share.
Basically, phantom stock.
Do we have legal practice in Lithuania for those?
Yes, we do. And basically, we have looked at some court cases, administrative court cases. So basically, this is the normal practice. Nobody buys the shares. They usually receive some sort of cash benefit in regards to how the price of the shares changes in time. But this is the tax issue that we will discuss a little bit later, because the law only gives the incentive when the employee actually purchases the shares and makes the actual deal on the shares, and then he sells them. If you have these phantom shares or stock appreciation rights or something similar, where you make a contract with the employee that he will receive certain amount of money in regards to how the value of the share grows. So, for example, today the value of the shares is €1. In a year it will grow, it will be €10, and I will receive as an employee €9 if I work long enough in the company. I don't have to make a purchase, I don't have to put my own money into buying the shares, but I will just receive some value in money in regards to the growth of the shares. So basically it creates the same effect as a stock option, but I don't have to purchase and go through all of the burdensome administrative procedures to do that. However, there is a problem with this solution.
So I start. So basically there are two types of income, and governments on international basis have decided that if you have capital income, capital investment related income, it's not taxed with social security payments. Then employment related income on worldwide basis is regarded as subject to social security taxation. So When thinking about stock options, one have to decide what it is. It is also agreed that when the stock option is realized, when a person already has the share in its ownership, and then afterwards transfers the share. So this is understood that it is already a movement of capital, therefore there is no risk of social security taxation. However, up to this point, it's up for the countries and their internal policies to define what it is. And unfortunately, Lithuania has went to this direction where all the movement of stock options is regarded as employment-related income. Therefore, before the exercise moment, if let's say the stock option as a right is sold to anybody, the company, the unrelated persons, it is regarded as employment-related income. Therefore, effective tax rate is 42%, which means 15% personal income tax and 39.98% of social security taxation.
And it's the same for the phantom options, because it's basically it's cash. It's not, it's not shares that you just receive and then sell. Then for the phantom options, just they are taxed as employment-related income with this 40+%, and it's already tested in reality because Sanitas was the first Lithuanian company to issue phantom options, and we structured that for them. And then just they were happy, but all the employees needed to pay all those social insurance contributions, etc., which it's quite a huge sum of money.
Yeah, but I have not finished. Okay, I have not finished. Like 1,000 points is still remaining. Yeah. So, but please.
Okay. So yeah, I just wanted to add a little bit to what Akvilė has said, that Lithuanian legislation doesn't make any sort of recognition of all of those sophisticated tools as phantom stocks, let's say, or stock appreciation rights. They just mention stock options very briefly, but all of those other tools that exist in normal world are not recognized in the legislation, and the legislator says, okay, whatever you pay to the employee, it doesn't matter how you call it. You can call it all those sophisticated names. Is regarded as basically part of the salary, and you have to tax it with social security tax, with personal income tax, all the taxes that exist, and then the tax burden is quite big. So for that reason, you really have to think whether you actually want to use this tool, because it will be taxed just as any kind of payment.
I know you're working in Venture Capital Association. You are, yeah? So what's your perception in terms of lobbying for normal, stock legislature in Lithuania? How would you say your work with government? How is it? Do you see any perspective?
Well, I can comment that we are working from two angles. Elena is working with just Startups Lithuania, just where she's trying to push all those tax incentives from the startup perspective, and I myself I'm working with Venture Capital Association, where we also are pushing the same, but from the funds already perspective, that just without this basically effective and optimal stock option just regulation, and especially not regulation but taxation, this tool is not just attractive in Lithuania, because from legal side you can just structure whatever you want. When it comes to taxes, then just you have those just headaches. So I would say that this new government that we have now, they are quite positive, and they are now searching how to position Lithuania and themselves, what they want basically to achieve during this 4-year period. And it's very good news that basically they just picked up startups as one of those focus areas. The funds also just venture investments as another focus area. So they're quite open about just hearing the problems and considering how to solve them. And I may say that from Venture Capital Association, just last week we met Minister of Finance, 1 month before Minister of Economy, and they both said that basically they will do whatever it takes to make the environment, just an ecosystem for startups here, viable and effective. So. And those problems that Elena is referring here about tax issues, so they are already known to the government, and I really hope that during 1 year or so, because it takes time just to change tax laws, just we will have some positive movements there, because the political will is quite good, and just they are quite open for discussion.
Yeah, so very good news. But now coming back to reality, and
can I continue?
Sure.
So just because it's very important to be precise, I'm very stubborn to finish the idea to make the full view, especially as it's filming. So as a start point, an employee is granted a right to exercise a stock option sometime in the future. And let's say till that moment, the employee chooses not to sell this right, and comes to the vesting period. The vesting period finalizes, and then let's say employee decides to exercise its rights and acquire the share. This is very important, that this is not only Lithuania, already the whole Europe, with certain exceptions, has moved to the direction that this is the moment which is regarded as, again, taxable, because basically the employee receives income in kind, like a fringe benefit, by paying a small amount, let's say €1, and receiving shares that market values of higher value than €1. So the difference between this €1 or 0, if the employee has not even in fact paid, is regarded as, again, employment-related income. And then what we have, 15% personal income tax, then 9% social security that should have been paid by employee, and 30.98 social security taxation that should be paid by the employer. So all in total, 55 approximately %. So this is the taxable moment. However, let's say United States have a different approach, and they regard that the taxable moment is not the moment when the employee receives this shares, but the moment when the employee that received the shares sells these shares. So as I've mentioned before, then this income is regarded as capital-related income, and we don't talk about social security taxation. But also in Europe, there are countries that have chosen, let's say, to tax the moment when the employee is granted a right of a stock option right. So then, to make it even more complicated, if you have an employer that is moving,
enough, really, so please
one sentence, that is moving in between two jurisdictions, and let's say one jurisdiction says that I want to tax with the social security and personal income taxation the moment when the stock option was granted, and the other country, let's say Lithuania, says while being in my country you have exercised your right to the stock option, and we want to tax all the difference between the acquisition value and the market value. Then you have a double taxation, and basically no means for the eliminate this double taxation. So So it is difficult.
So incorporating a mother company, for example, in London, and then selling giving stock options of the mother company in London to Lithuanian employees is not really an option.
It is,
or is it?
No, like the taxation of personal income tax and social security taxation is fixed to a place where actually the person is performing the factual work. So working in Lithuania, you are bound by the rules of Lithuania. The most important thing is not to move. Let's say if you have a 3 years vesting period, so not to be in one country where you are being granted the stock option and then move to Lithuania when you are exercising the right. So, but this is like one of the aspects which is not very common, but just to put more complexity into the topic.
No,
you know?
but basically, if you are granted the options of the UK company and you are just residing in Lithuania and a tax resident in Lithuania, you will need to pay taxes according to Lithuanian rules.
Social security as well.
Yes. Yeah.
Because stock options in any way with either jurisdiction, their job-related income, and it's taxed with social security.
Unless you have these incentives that are applicable, and I believe that now, especially like European Commission is very pushing the countries to be more liberal, to reduce these taxes on especially on startups. So at like Estonia, Lithuania, and Latvia, we all have almost the same rules. That says that if you if you have this vesting period of 3 years and you exercise your right to stock option after 3 years, then this fringe benefit, the shares, the market value is not taxed with the social security taxation. However, I have to say that Lithuania, for somewhat reason, is more stricter than Latvia and Estonia, because Latvia and Estonia, they exempt the fringe benefit at all. It's not taxable in general, neither by personal income tax, neither by social security taxation. However, in Lithuania, you have an exemption only from the social security, and personal income tax is applied in all cases to all income, despite who pays, despite in which form are you paid. So 15% will be paid like as a general rule.
It's because Lithuanians are more creative in tax saving schemes.
Optimization, we call it.
Yes.
Okay, so it's really a very complicated venture to have these stock options. Do many startups in Lithuania have them?
I have seen only 2.
Actually, in all the investments that, for example, when the fund comes, there is always a pool dedicated to the stock options, but the ones who are really, just setting the structure, just signing the agreements with the employees, just basically agreeing on the terms, how they will vest, who will pay what, etc. It's quite a limited number of startups who are doing that, because it's again, from the start, from the business ideas, and business arrangement. Okay, I will give you like stock option, and assign your lawyers to do that, and then the lawyer starts asking all those tricky questions, and it takes several rounds and a number of rounds to agree, how you will do that. And it's not every startup that wants to do this exercise.
I just wanted to add a little bit. So basically, there's just one scenario where you will not be taxed with social security tax on those fringe benefits, as Elena mentioned, and in the other scenarios you will be taxed with basically everything. So for that reason, a lot of companies choose to issue phantom stocks or set up some sort of incentive plans which is tied to some milestones of the company or change of the price in shares, but the employees don't actually receive the shares or stock options. Because if you will be taxed in any case, then why go through this burdensome procedure and issue the shares, buy the shares, have all of this movement if you can achieve basically the same effect by designing a similar structure. And basically, maybe you will have other milestones to consider, not only the share value, because maybe you want to launch a new product, maybe you want to succeed in a certain area or in certain city, or you have something else, maybe you want to have a lot of users of your product or your platform. So maybe you want to include that into incentive plan as well. So if you only have stock options, you were basically limited to, as a factor, to the change in price of your shares. If you design a similar plan, but without the actual purchase of shares, then you can include other milestones, which are very important for your business. Because what you want to do is you want to motivate the employees to take certain actions for your business to succeed, and maybe you have, some short-term goals to consider as well.
Mm-hmm. Yeah, bounding the motivational scheme to a set of KPIs really makes sense, especially in startups or other privately held companies where the actual stock value is is known on some market event, be it IPO or any other kind of liquidity event when you know the real market value of the thing, and because otherwise it's just clouds.
Because basically the companies choose to use this tool, the stock options, because they have no money at the time to incentivize the employees to work, and they say, well, at this time we can't pay you much, we know you're very valuable and have a lot of knowledge, but at some point in the future, when we make the exit, when we IPO or sell or whatever, you will receive a lot of money. But the employees, I believe, they look at the short-term incentives as well. You do not have to pay the employee today, some sort of amount of money, but maybe in a year he will actually feel that he already put a lot of himself into the company, and he would like to get something out of it, just to keep himself working in a company. Because if you design this very long vesting period, let's say 3 years or 5 years or whatever, maybe the employee will no longer work in the company, or maybe he will fall apart with his vision and mission from the company. So you have to think about that as well, because you have to consider your goals when you take this tool and you try to employ this tool into your company. What is your goal? Is your ultimate goal to retain the employees, or is your ultimate goal to keep the employees working for the low price with the promise that they will receive something in the end?
We were joking that she's a bit a bad policeman, and that I'm playing this good policeman's role, because it's not that difficult, and it's really not that
okay.
And 3 years time for development of the idea is, in my opinion, as I'm a bit perhaps older generation, it's not that long time in my perspective to check the idea whether it's working, and perhaps it's worth trying. Also, I've seen that the States, I've mentioned the Baltic countries, the majority, like UK and other countries, they all apply this 3 years waiting period for the application of the tax incentive. So this is at least a good to know thing for Lithuania. We're not asking to wait for 5 years in comparison to other countries. And it's also the law does not say what kind of shares it should be received by the employee, whether it should be the employee shares, group company shares. The law does not restrict to issue new shares, it can be acquired, because the law is silent upon these questions. Therefore, if we are like liberal, we interpret them widely and that say that the law does not restrict. Therefore, if I receive shares of a mother company or sister company, then I'm still eligible to the tax incentive. Of course, with a certain amount of risk, but we are startups, we're up to taking risks. And but of course, the most important thing is, and what is Jovita and we are trying to emphasize, that in order for the tax incentive to be applicable, unfortunately the employee has to receive the ownership to the share, and then it's a bit complicated.
Yeah, because the employee has to invest his own money with the promise that he will receive more money, but you have to actually go through that procedure to get there.
But then maybe the practice could be like, okay, buying the share and then selling it back to the company?
No, because again, it's one of the issues that we are promoting through the association, but according to the current legal regime, there are so many requirements and restrictions for the company to purchase its own shares that it's almost impossible for a startup company to do that. Because you need to have profit, you need to have reserve, you are just limited up to 10% and blah, 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 which means that it's not an option in practice.
Okay.
For the company itself, but however you can sell the shares to other shareholders.
Yeah, but then, you know, those shareholders need to have money. So.
Yeah, as well. So.
Okay, so really it seems that we have to keep our fingers crossed that the enthusiasm of the new government will translate into some proper legislature regarding the stocks and other things. So now, dear audience, do you have any questions regarding taxation and or stock options? Yes, please.
Yes, I have one question. You mentioned that after 3 years, social tax is not applicable, right? What if employee leaves in 2 years and 66% of stock options was vested?
Unfortunately.
For the employee?
Yes, you have to. It's a strict rule. You have to. Of course, it also depends upon the rules. If, let's say, if under the stock option plan signed between the employee and employer, the requirement not to work is stipulated in the contract. Of course, that would be very interesting if you were permitted to receive a stock option, though you're actually not working in the company anymore, because that's a bit against the vehicle itself. However, the law is the Social Security law is silent. You are not obliged to remain the employee if you receive the shares after this three years. However, from the personal income tax, as I've mentioned, you've taxed by 15%.
So basically, if your contract is structured in a way that after 2 years you leave the company and you still retain the right to acquire the shares after 1 year, although you're not working in the company, and you just acquire, you know, these shares into your ownership after 3 years from the just signing of the contract, then you will be just tax exempted from the social insurance contributions. But it depends, you know, whether you are entitled just to retain, you know, this option after you leave the company after 2 years.
Because it doesn't really make sense from the company perspective.
No, it doesn't. But basically, you know, just I've seen and just several cases when usually the option agreements are drafted not by lawyers or by the company himself Googling, you know, just for the option agreement. And then just they have cases, you know, when the employee leaves, but this was not, you know, just discussed in the agreement, and the employee reserves the right to the shares. So
the idea was that, let's say in company it has every year, proportionally, and then the employee can leave, and it can still, the employee can still have stock options, and then it's not transferred to shares, but he will keep them for another year, and then will, let's say, transfer to shares. Then it's only 15%. Right?
Yes, yes, because it's just you will receive, basically it's the moment when you receive the shares into your title, into your ownership. So if it's after 3 years, independent whether you are working with the company, not working, whether you advise or whatever, it's not linked to the employment with the company. It's just, the period that, when you are granted the option and when you just basically exercise it by just receiving the shares into your pocket.
And if your employee is tax resident somewhere else than Lithuania, then he must, to whom he's paying social security?
That's a good question. Let's say if a Lithuanian,
I'm employing somebody from, let's say, Estonia, so I think the Estonian law will apply to him, not Lithuania.
Yes, but as I know Estonian law, so let's say your employee goes to Estonia, yes, it receives this fringe benefit from Lithuania, but the fringe benefit is owned by the employee that is residing, and let's say now is being a tax resident in Estonia. So then Estonian rules apply. If the 3 years period has passed, so then you're not taxable in Estonia.
His tax residence law will apply.
Yes.
Yes, exactly. Yes. Yeah. However, just to make it also clear that when an employee is receiving fringe benefits, all the taxation is covered by the employer, basically. So let's say when in Lithuania we have this weird system where the employee is a payer of personal income tax. 15% is withheld from the salary. Also 9% is of social security taxes is withheld from his salary, and then on the top of the salary already the employer pays this social security of 30.98%. However, when you have a fringe benefit, in practice usually employers do not ask the employees to pay the taxes, So the companies are taking the responsibility, and if no tax incentives are applied in the case, so the companies, employers, they assume all part of the taxation, and that is in total 55%. So let's say in the situation you've mentioned, if the tax incentive in Estonia did not apply, so they had to pay the 33% of social security taxation, Lithuanian company would be paying to the Estonian budget this taxes.
The solution is not to employ him.
The solution is to wait 3 years. The solution is to wait 3 years. Yeah. Magical number.
But what about if it is not Estonia, it's any country like?
You have to, then of course the same, you have to see what are the tax rules in Estonia. In general.
In the country tax residence.
Stock options, and that's it. So when he's not employed, there is no place to pay social security taxes. After 3 years, you will give him stock option in his country, he will pay income tax likely, but that's it. So.
Yeah.
What about freelancers? You have contracts.
So this is also, let's say, but I can say it is not, I don't know about the worldwide, but at least in Europe, we see that tax incentives are granted only to employees, because there are type of stock options that are granted to consultants, management boards, whatever, but usually they are not subject to tax incentives. It's only employees and this employment-related income. So basically, the countries are saving employees from this huge amount of tax that is, in majority of cases, very high rate.
And for freelancers, it's usually the first question whether it's just a true freelancer or just some hidden employee, and if just this is detected, then just all those social contributions will be just calculated.
Plus interest.
Yes.
We have to add plus interest, because also if on the contract it is written that it's a consultancy contract, it doesn't mean that it's actually consultancy contract. It could be hidden employment, and then there are ways to detect hidden employment, whether the employee follows a certain set of rules, the person follows a certain set of rules, then he's actually considered employee, and all of the gains and everything that he received from a company could be taxed with also social security.
Yes, because social security rate is that high. Companies and employees are becoming very innovative and very creative how to change the legal relationship from the employment relationship to other kinds, just to save this social security tax.
So optimize your taxes, but to an extent. We had a question over there.
So in Latvia, the startup law has just been put in practice from the start of the year, and you mentioned a couple of cases with regards to stock options where, again, Latvia and Estonia are more beneficial than Lithuania. So a three-headed question, I guess, comparing the three jurisdictions, now apart from the startup law and the stock options, are there any other cases in which Lithuania is currently a more beneficial jurisdiction, or are we sort of losing out on other areas? Secondly, you mentioned that it will take 1 year to make any changes. Is that sort of a realistic term, or are we talking about for a platform of changes? Is that realistically 2-3 years? And lastly, how many startups, if you can disclose, you have already relocated to Latvia?
Okay, so basically what is very important to notify and to clarify that the Latvian law is not some kind of miracle, because in order to get the tax incentive in Latvia, you have to be resident in Latvia and receive an investment from Latvian venture fund. So you just cannot reallocate to Latvia and then claim for the tax incentive. As Akvilė mentioned, from the Startup Lithuania and together with the partners, we have prepared proposals for the government, and the government has clearly stated that they're willing to make Lithuania a startup heaven. So the social security question and the problems that it brings to the startup community were raised, and proposals and even formulations of a tax incentive that could be applicable in Lithuania was formed. So it's already up for the government to analyze them and then somehow, hopefully, to make them to practice. As the Minister of Economics has so clearly publicly stated that he's willing to make the changes, we hope that it would not take more than a year, but I cannot, it's very hard to predict. And regarding your last question, I have not yet moved or assisted startups, however, and I told it also publicly that I have already consulted, I had to consult at least 3 startups, especially on the moving possibility. So our government knows how important this question is, and it's really, when we have a startup as a business, it's very flexible, it's not fixed to one jurisdiction, so it's not hard for the startup to move to Latvia and approach venture funds of Latvia. There is no difference from where to receive the investment. So,
well, there is because yes, because for example, those funds, venture or startup funds that are financed through, for example, state or EU structure funds, they have very clear geographical limitations. And Lithuanian, just those funds that are established in Lithuania, they must invest only in startups that are located in Lithuania. The same exists in Latvia. So, we are always discussing, with the politicians and, showing them, Latvia, Estonia as the examples, but in many cases, it's more PR companies that Estonian or Latvian are better than us. And just as Elena said, okay, we can take, this statement that in Latvia, just life for startups is better. But if you dig into the reality, it's very, very difficult basically to fit into those exemptions because there are so many conditions which of course PR campaign is silent about.
We will make a better PR campaign.
Okay, there was a question here. Somewhere?
That was my question. So.
Okay, any more questions? No more questions. So let's give a nice round of applause to the ladies.